Okay, this is going to be a really quick constitutional law. First Amendment free speech. First Amendment applicable to the states through the Due Process Clause of the 14th Amendment provides Congress shall make no law abridging the freedom of speech. However, in a public forum, reasonable regulation of time, place, or manner of speech is allowed. Regulation that is not content neutral must satisfy strict scrutiny. A regulation that is content neutral must pass intermediate scrutiny. Under intermediate scrutiny, the regulation must impose only reasonable restrictions on the time, place, or manner of speech and are narrowly tailored to serve a significant governmental interest. And it must leave open ample alternative opportunities to engage in speech. Strict scrutiny is that the restriction has to be narrowly tailored to like the specific so yeah, that one's coming up. Establishment Clause. In general, the Establishment Clause prevents religious activities from being conducted in public schools because their primary purpose is to promote religion. However, student religious organizations cannot be prohibited from using school facilities that are available to other student groups, because such a prohibition would violate free speech under First Amendment. Allowing student religious organizations to meet on school grounds does not violate the Establishment Clause. First Amendment protects freedom of speech, but reasonable restrictions can be imposed, time, place, manner. Such regulations can be content neutral regarding subject matter and viewpoint, be narrowly tailored to serve a significant government interest, leave open alternative means of communication. Vague or overbroad regulations are not constitutional. Entering a closed meeting does, getting arrested for that does not violate. Equal protection under the 14th Amendment. Equal Protection Clause of the 14th Amendment provides all persons are entitled to equal protection of the laws. However, it only binds state actors. Private actors are not bound by the Equal Protection Clause unless 1. The actor is performing a traditionally public function, 2. There is judicial enforcement of a private contract, 3. There is sufficient entanglement between the state and the private actor's activity, or 4. The state is encouraging the actor to engage in private discrimination. Courts employ intermediate scrutiny analysis in cases where discrimination is based on gender. State must show that its gender classification serves an important objective and that its discriminatory practice is substantially related to the achievement of that objective. Commerce Clause. Under the Commerce Clause, Congress may regulate the channels of interstate commerce, the instrumentalities of interstate commerce, and the activities that substantially affect interstate commerce. Congress is concerned with the cumulative effect of economic or commercial activities that substantially affect commerce. When Congress regulates an economic or commercial activity, the court will uphold the regulation if Congress had a rational basis for concluding that the class of activities subject to regulation in the aggregate has a substantial effect on interstate commerce. If the activity is not deemed to be economic or commercial, then a court will not aggregate the substantial effect and the test becomes much more difficult to pass. In striking down a law giving a cause of action to victims of gender-based violence, the Supreme Court refused to aggregate the effects of such violence because it determined the violence against women was not economic activity. 10th Amendment. 10th Amendment provides that Congress may not interfere with the state's lawmaking or order state officials to act as administrators of federal programs. 10th Amendment is a weak limitation on Congress's commerce power. Congress may not commandeer the states to regulate private conduct, but generally applicable federal laws that regulate states do not violate the 10th Amendment. Eleventh Amendment. 11th Amendment prohibits citizens of one state from suing their own state or another state in federal claims for money damages in federal court or state court without the state's consent. 11th Amendment recognizes the state and their governmental immunity. It applies to both diversity suits and federal question. Concept of governmental or sovereign immunity, which extends to state agencies, means that the government may not be sued without its consent. Congress may abrogate a state's immunity where 1. The act asserts that it's abrogating the state's immunity. 2. Congress enacts the act under a grant of power that may abrogate the state's immunity. The Commerce Clause alone does not support Congress's abrogating a state's immunity. Okay. State action requirement under constitutional rights can be violated only by government actors, not private actors. However, state action can be found in the actions of private actors in certain circumstances. Public function theory, where a private entity is carrying out activities traditionally exclusively performed by the government. Private entity may be considered a state actor. Content-based restrictions. Content-based restrictions are expressive activity in a public forum violate First Amendment unless the regulation passes strict scrutiny. However, law which regulates expressive activity is allowable if the regulation is narrowly tailored to further a significant government interest. The true purpose of the regulation is not the suppression of ideas, and this restriction on speech leaves open alternative channels for expressive activity. The Supreme Court has held that anti-litter ordinances which prohibit person-to-person leafleting do not pass this test and thus violate the First Amendment. Equal protection. Equal Protection Clause of the 14th Amendment provides no state shall deny any person within its jurisdiction the equal protection of the laws. The Equal Protection Clause comes into play any time that the government treats similarly situated persons differently. The Supreme Court has delineated 3 levels of scrutiny to be used. Suspect classes such as classifications based on race or national origin are subject to strict scrutiny. When there is no suspect class, courts use rational basis review. The burden of persuasion is on the plaintiff to show that the measure being challenged serves no legitimate government interest, or it is not rationally related to any legitimate interest. The courts will give great deference to the legislature. Legitimate purposes include variance of the police power, including public health and safety. Rational relationship is a minimal requirement. The law cannot be arbitrary or unreasonable. Courts apply rational basis review to age-based classifications. Okay. Rationally related to a legitimate interest. Section 5 of the 14th Amendment gives Congress the power to enforce by appropriate legislation the provisions of the amendment. Congress's power under Section 5 is remedial, not substantive. Congress is limited to enacting laws that prevent or remedy violations of rights already recognized under the 14th Amendment by the Supreme Court. To show that the action is remedial, Congress must show that 1. State governments have engaged in widespread violations of the amendment. 2. The legislative remedy is congruent with and proportional to the violations. Okay. So the Congress can't add a substantive right not recognized already. Class A. Oh, it's a federal jurisdiction. Federal district courts have federal jurisdiction over all civil actions arising under constitutions, laws, and treaties of the United States. Diversity jurisdiction over matters involving litigants who are citizens of different states if the amount in controversy is more than $75,000. Complete diversity between all plaintiffs and all defendants is required. There's an exception to the complete diversity requirement for class actions. In class actions where the class contains over 100 persons and the amount in controversy exceeds 5 million, diversity need only be minimal, meaning that federal jurisdiction exists if any single member of the class is diverse from any single defendant. Corporation is a citizen of the state of incorporation of the state where it has its principal place of business. Principal place of business is the state in which the corporation's high-level officers direct, control, and coordinate the corporation's activities. Individual is a citizen of the state where they're domiciled, which is where the person has a physical presence and the intent to remain indefinitely. Erie Doctrine. Under the Erie Doctrine, a state law will apply if it is a law that deals with the substantive rights of state citizens. However, federal courts will use federal, not state, procedural rules. Under Rule 23, a class action may be maintained by a party if the court finds that there is numerosity, commonality, typicality, and adequacy of representation. Federal rules for class certification apply to all class actions in federal court, including those based on diversity. State laws on class certification are superseded. Standing. A representative party in a class action suit must have standing to bring their claim. Federal jurisdiction is limited to cases and controversies. In order to establish standing, a person must show 1. Injury in fact, 2. Causation, the injury was caused by the challenged action, and 3. Redressability. Plaintiff must show a direct and personal injury, actual or imminent, caused by the action that he is challenging. Where the plaintiff has not suffered any concrete personal injury or harm, he does not have standing. Okay, I guess this one has a little crossover with corporations. Under the MBCA, shareholders of record are entitled to examine board minutes. Shareholder may inspect and copy records only if 1. The demand is made in good faith and for a proper purpose, 2. Describes with particularity the purpose and the records to inspect, and the records are directly connected with the purpose. Shareholders generally able to show good faith if they present evidence establishing a credible basis for belief in possible wrongdoing. Proper purpose is one that is reasonably relevant to the demanding shareholder's interest as a shareholder. Purposes such as protecting their financial interests in the corporation, their interest in voting or selling shares, or bringing a lawsuit to protect these interests have been found to be proper. Shareholder action. Submission of shareholder resolutions for shareholder action at shareholder meetings is generally accepted under common law principles as a fundamental right of shareholders. Shareholders may express their views on corporate matters in non-binding precatory resolutions. Shareholder proposals cast as recommendations or requests that the board of directors take specified action are generally proper. However, a shareholder proposal that would bind the corporation or the corporation's board is generally not considered proper. The exception would be that when the shareholder resolution seeks to require corporate action by means of an amendment to the bylaws. First Amendment. First Amendment, which is applicable to the states through due process clause of the 14th Amendment, provides Congress shall make no law abridging the freedom of speech or of the press or of the right of people to peaceably assemble and to petition the government for redress of grievances. The Supreme Court has ruled that corporate spending on speech merits the same First Amendment protection as speech by natural persons. Hence, Congress may not censor such corporate speech. That is constitutional law.